All rise. Court of Appeals Division 1 is now in session.
Good morning. You may be seated. We are here on our case number 1 CACV 170302 FC Young versus Young. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, and we'd be grateful if you would, when you approach the podium for the first time, identify yourself and your client for the recording. We've reviewed the record in the case and have read the briefs. We've also discussed the case among ourselves in a conference. So with that, you may proceed.
Thank you, Your Honor. I do wish to reserve at least 10 minutes for rebuttal. My name is Alan Cook, and I represent the appellant, Monique Young. And Your Honor, good morning. I hope you find this to be a wonderful day in your life. The appellant's brief is based upon three issues that I think are relatively straightforward. Taking them in reverse order, appellant has asked for fees and costs on appeal, owing to the great disparity in income between these parties and the fact that I think that with respect to reasonableness of positions taken. And we've cited those reasons for that and the statutes and rules in our brief, opening brief and the answering brief, reply brief. Taking them in reverse order, we did ask that the court direct the Superior Court to address this issue about accrued annual leave and sick leave, which in this case aggregates something over $50,000 because it wasn't divided. And so under 25 ARS Section 25318D, that's an asset that should have been divided.
That was not raised below, is that correct?
No, Your Honor, it wasn't. But a motion could be filed in the Superior Court going back and ask the court to do it because it wasn't allocated to anybody. It wasn't divided at all. So, but there are no Arizona cases that specifically say this about these assets. And it's not always true that they're worth a lot of money, but particularly with federal employees and under the civilian system, their accrued sick leave can be grossed into their retirement pay, and it can make a significant difference in what the retirement benefit is.
Won't that only come into play if they still have accrued sick leave at the time of retirement? How would we know that at the time of
well, you might not, but he has it now. And if he chooses to use it for whatever reason after the divorce.
Accrued sick leave, so he gets sick next year and gets to use his accrued sick leave. That needs to be divided up. Why would that be divided up at this point?
No, Your Honor, I think it should just be factored into the retirement because we know that he's got more than half a year in accrued sick leave as of June 30th of 2016, which is, for all practical purposes, the date of service, 2 days after the date of service. And so, but I mean, this court can make whatever ruling it wishes. I think the annual leave is plainly clear because he can take that with him. If he doesn't use it, he can get paid outright for it, but he gets to use it afterwards. But it is, I think, plainly a form of compensation, and his own records and exhibits submitted to the trial court reflect that. And so, and I agree that if he decided to quit service, he might lose his sick leave, but that doesn't mean it isn't a substantially accrued benefit. And I agree that viewing sick leave and viewing annual leave could be viewed differently.
But you could, your client could go back to the trial court now and ask to have that allocated, right?
Yes, Your Honor.
Okay.
Could.
Okay.
And that's the reason we're asking that the court might address it, because there are no Arizona cases that speak to the issue.
Okay.
So, with respect to the principal issue, the appellant wasn't awarded any portion of the $315,700 in thrift savings benefit. It's like a 401k plan. That was all awarded to the husband. And under the case law, you cannot award spousal maintenance, for example, in lieu of property division. We've cited Buttrick and the other cases that deal with that. And I think the statutory scheme is likewise clear. And I think wife's entitled to her half of the TSP, and that would be $315,700 divided by 2 as of June 30, or call it June 28, 2016, plus gains and losses from that day forward.
The record contains a joint pretrial statement that was filed by husband,
Yes.
not signed by your client or a
Correct.
lawyer for her. It though contains a representation that the parties had agreed on the characterization of the accounts that were listed, or the assets that were listed there. Was that an accurate statement that both sides had agreed?
Well, Your Honor, the parties did sign a form, a property form, and the property form is the property form that I've attached as an appendix to the opening brief. And I think it's trial exhibit 6. All of the trial exhibits were husband's exhibits.
Okay.
And that has the number $303,000 in it,
Right.
but it doesn't match what the document was. It was actually admitted as an exhibit at court. That was what the balance was as of the end of March of 2016, but the service date was June 28th of 2016. The June 30, 2016 statement shows that the balance in that account is $315,700, and so.
But your client is also asking for spousal maintenance.
Well, she had asked for spousal maintenance, and the court didn't award her spousal maintenance until it signed its decree, and then it did award her spousal maintenance. And so, as it happens, even though it might have been an odd way to get there, the fact of the matter is there's nothing wrong with the result, and it's just. And we've cited the court to the case law that says that when you look at spousal maintenance, you look to see if the record supports the award. And in this case,
What are the findings that would support an independent award of spousal maintenance, assuming it's not intended to take the place of a division of community property?
what are the findings? I don't think the court made findings about why she was or wasn't, just said no in its minute entry. But
so
it
what-
didn't say that in its decree.
Well, let me ask, on the statute 25318,
Yes.
in your view, does that contemplate that community property can be divided, that you can use spousal maintenance as one way of dividing
No.
community property?
No. And if you read the case law, it tells you why, Your Honor. Because among other things, if you award spousal maintenance in lieu of property, and I will tell you that in terms of settling cases where you have massive disparity in income between parties, lawyers have over the years used spousal maintenance as a way for, say, a doctor to buy his wife out of his practice because the doctor might be in the 45% tax bracket and the wife in the 10 or 15% bracket, and you have that big difference in there where both parties can save money because of the tax consequences. But typically, when you do those things, the gross amount of money is significantly more than the amount that's owed because the amount that's owed is after-tax money and the amount you're paying is before-tax money. And so, but those are negotiated agreements that people have entered into. The trial court has no authority to do that at all because the spousal maintenance could stop the next day. The husband could get hit by a truck and wife would get zero.
In this case, would the spousal maintenance be cut off? Did it have a specified period? Did it just say for as long as she was alive?
It's either paragraph 14 or 15 of the decree, Your Honor, and I can read you the whole thing. It's right here.
I'm just interested in if it cuts off at any point.
It's one sentence, paragraph 14 at page 7 of the decree. Effective April 1, 2017, petitioner shall pay to respondent the sum of $1,500 per month for spousal maintenance for a period of 84 months. That's a gross amount of $126,000 if you live that long. It's not half of the TSP. It's only about 80% of her share of the
But
TSP.
in your view, if she died the next month, that payment would not, no further payments would be owed to her estate?
If he died, it would stop, and if she remarried the next month, it would stop under the law.
If she died, I'm saying.
I'm saying if she remarried, it would
Right.
stop.
Okay.
And if it has to stop if the receiving spouse dies in order to qualify for tax deduction as a matter of law. It doesn't have to stop if he dies.
Right. I'm just looking at the language of 25318 that says if any part of the court's division of joint, common, or community property is in the nature of child support or spousal maintenance, the court shall make specific findings of fact supporting it. Doesn't that contemplate that maybe the court can do it under, if it explains what it's doing?
I don't think so, Your Honor, but the court didn't do that in this case. All it did
Let me ask if the court just made a mistake and awarded it as spousal maintenance instead of calling it, this is the property division. Is it your view that your client is nevertheless entitled to spousal maintenance and is also entitled to a division of that asset?
Yes, Your Honor. I think the court, I think it's entirely improper to use spousal maintenance for any reason.
But if the
as
court
a
put on the
property division.
record, let's say the court put on the record, rather than dividing this asset, I am going to award mother spousal maintenance in the amount of $1,500 per month. If it were that clear, would you still be arguing that she's entitled to spousal maintenance and she's also entitled to half of the asset?
Well, I would be, Your Honor. And if the other side didn't like it, they could appeal it. But they didn't do that. They haven't appealed it.
I'm asking, what would be the basis for your argument if you're saying, if the court said, I am dividing this asset in this way, rather than giving you $157,000, I'm going to give you $1,500, I'm going to enter an award of $1,500 per month of spousal maintenance?
Your Honor, I suppose the problem is that the court has no authority to make an award of spousal maintenance that says that it can't be modified or that it cannot or would not terminate on the wife's death. It cannot do that. It can't even be spousal maintenance if it terminates on the wife's death. And as a matter of law, it does. And in this case,
spousal maintenance,
it has to terminate on her death to be spousal maintenance. If I misspoke, I misspoke. And I apologize. It has to in order to be tax-deductible spousal maintenance.
For the husband.
Yes. And taxable, it makes it taxable to the wife.
Right.
And if you don't say if it is or isn't taxable, in theory, you could say it's not taxable, in which case that would be a difference. But on the other hand, it still terminates as a matter of law pursuant to ARS 25327. And so you never know if wife's ever going to get it or not. And that's why you cannot use spousal maintenance to divide property, Your Honor, because it's so defeasible. And I cited a case out of the NACE, I think, where it says the right to receive spousal maintenance is as tenuous as a thread or a breath.
The argument is that I understand you to be making is setting aside spousal maintenance. If we take the $1,500 a month payments as what the court intended really to be a means of distributing the community asset, your position is that's still wrong.
That's correct.
That's wrong because it's not enough.
Well, it's not only not enough, but the thrift savings plan under the law, Your Honor, the Thomas case and Gutierrez case, these cases are legion, which says that a spouse shouldn't have to use up their nest egg, their retirement savings to live on.
Well,
And
yeah.
And one of the things that happens with these TSP and 401k programs and things like that is they're allowed to accumulate value without tax consequences. And so that means that their growth rate is significantly higher than what you might get, for example, with your after-tax personal savings, because you don't have to pay income taxes on the growth. And then when you're old enough and you have to draw it down, you pay income taxes then, but typically you're in a much lower tax bracket. And so I can't find any good justification.
But it's not using it up. All you're really arguing is that you're losing the tax benefit from having it, because there's nothing that keeps her, assuming this is a wrongfully characterized payment, she could simply put that money in the bank and not use it up, but she's not getting the tax deferred benefits of having it be in a retirement account.
Well, not only not use it up, but she's going to have to pay the taxes on the gains as she goes. And so,
yeah, that's it.
And so it's not the same thing. Here she would have a lump sum, which which accumulates value much faster.
And she also pays, and she also pays tax on the receipt of the monthly payments.
That's correct.
If she got it in a quadro, and she decided to withdraw $1,500 a month to live on, unwise. You don't do that with retirement, but you could. Would she be taxed on that?
Yes.
As she takes it out?
Not only tax, but there's a 10% excise tax on top of that if she's not age 59 and a half.
So that's kind of a wash. But the fact that even if she took it and then put it right back in the bank, that's not going to appreciate in tax favorable conditions.
Not even close, Your Honor.
Okay.
And there was no evidence that it would. But I would submit to you, this case with respect to the spousal maintenance issue is just like Zale. I don't think there's any distinction between a case where the parties make a Rule 69 agreement that the court approves, and then the decree later says something different, which becomes the judgment of the court. And I think that's exactly what we have here. And I think that the court awarded spousal maintenance. Nobody appealed that issue. And I think wife is entitled to have her half of the TSP. Thank you. I'd like to reserve the remainder of my time.
Good morning, Your Honors. I am Mary Boyd Henderson. I represent Mr. Young, who is the appellee. I'd like to kind of pick up on a couple of remarks that Mr. Cook made just in the discussion of the difference between payments in the manner prescribed by the court of $1,500 a month as a distribution of the thrift savings plan versus getting them in another way. First of all, there are advantages and disadvantages to any distribution of retirement payments, no matter how you do it, whether you do it by a quadro, whether you do it and in monthly payments, then call them spousal maintenance, or in monthly payments and call them monthly payments. So, for example, yes, spousal maintenance has a statute that terminates it automatically on the occurrence of certain events. Mr. Cook is correct that by statute, unless the parties have agreed otherwise, spousal maintenance would terminate on the remarriage of the receiving spouse or on the death of either the paying or receiving spouse. And he's correct that there's language in a case out there that says that therefore spousal maintenance is tenuous. However, receiving a simple judgment is even more tenuous and has other negative consequences, which I think the trial court considered. So we approached this from the standpoint that the trial court felt that the mother should receive this distribution not through a quadro but through payments of $1,500 a month. The negative consequences of calling a judgment, number one, a judgment like that is much more easy for the payor to simply bankrupt or discharge in another way. It is not nearly as enforceable as spousal maintenance payments.
If it's a quadro, that's not going to be subject to bankruptcy, is it?
No, but again, assuming the determination of the court was to distribute the funds at $1,500 a month, which clearly, based on the record, it was. The judge determined that she would be paid $1,500 a month in payments.
But the judge is just trying to make an equitable distribution
Correct.
of the assets. And why would that be an equitable distribution if she's entitled to a quadro, and if she can leave it in there until retirement and gets the benefits of, and why would we necessarily assume that she's not going to do that? So it seems like you have to attribute the value of the quadro as the full value of it, and that there are going to be continued tax benefits from leaving it in there.
Well, a quadro is certainly one way to divide an asset like this, but I don't think that there's anything that mandates that an asset like this must always be divided pursuant to a quadro.
But don't you at least have to figure out and say, this is the, you can do the computation and say, this is the value as of today of the quadro, and you would factor in the fact that it's going to continue to accrue. It will defer, the income will be tax deferred, so you can put a value on that, and then you just award that value to it. But when you just say $1,500 a month that can cut off at the time of death, that seems to bear no relation to the actual value of the asset.
In our brief, we discussed several of the other things that were going on in terms of the property division at that point in time. In other words, my client was taking on responsibility for a home that was upside down. There were other debts that he was apportioned.
Does that total up to $157,000 or whatever it is to equalize the?
I don't know, but the other thing that the judge, I think, considered was the fact that my client was made responsible for the sole support of the children, and there is support. The anonymous case that's cited within Buttress, for example, discusses the fact that it's appropriate for a court to consider the fact that one of the parties is going to be primarily responsible, in this case exclusively responsible, for the support of the children, because there was no child support ordered. He had custody of the children, and there was no indication that mother was going to provide any assistance with that. And so the court is entitled to consider that in apportioning community property, and we believe the court did do that. So
you're saying that the court could have figured it was equalizing the assets by considering the fact that husband was going to have the burden of supporting the children without child support.
Correct.
But wasn't all that anticipated by husband in the joint pretrial? I mean, didn't he, in terms of the assets and the debt, he got exactly, with the exception of the thrift savings plan, he got exactly what he was expecting to get.
We obviously made an argument for the position that we had set forth. And just to be clear, the pretrial statement was not a joint pretrial statement. Mother,
Right, but I'm
it was
talking
your
what he
client's.
wanted.
it was our
What
pretrial
he-
statement,
and
correct.
it says it has blocks your husband, what he wanted, wife. And so, I mean, setting aside the child support for right now,
Yes.
I mean, one argument that I understand being made in the briefs is that, well, even if $1,500 a month for 84 months doesn't exactly equal out to what a Codro would get her, it's roughly okay because of the other distribution of assets that the court made. But husband didn't expect to, I mean, husband got exactly in terms of assets and debts what he wanted to, expected to get, right?
He was awarded what we requested, certainly. Okay.
So
in making,
isn't it hard pressed to say so beyond that, he shouldn't have to give her all her whole share of the thrift savings plan?
I can only say that in making the request that we made, we considered all of those things that I've just set forth, and we presented that to the court. So for one thing that is stated in the pretrial statement is that Mr. Young would waive the payment of child support. So that was part of the request as well. So
Not part of the initial request wasn't to pay any spousal maintenance, right?
part of the initial request was not to pay any spousal
Yeah,
maintenance.
and to divide the retirement account.
Correct.
So I'm just having a hard time seeing the math to get from, we'll divide that in half and it'll just be substituted for $1,500 a month. I understand if there's other things on the sheet
Right.
that show the 20 or 30,000, but when he wasn't requesting child support, that still doesn't seem to jive with I expect to give her half of the retirement account and everything else comes out. It seems like the only thing that's different is he does owe spousal maintenance, but he doesn't have to give her half of the retirement account.
Right. I mean, I think the way that it was put in open court was that the retirement would be paid at the $1,500 and that we would call it spousal maintenance in order to preserve what we argued was an enforceability provision. So in other words, the concern is in just awarding a judgment for $1,500 a month, someone can go and bankrupt that judgment. Someone can simply not make payments on that judgment. And if payments were not made on a judgment like that was simply a money judgment, it's much harder to garnish. With spousal maintenance, you can simply do a
That still
wage.
doesn't say the actual amount is enough to.
No, I mean, the math is the math. I can't, argue numbers that don't exist. I mean, but I do, there is ample authority cited in our brief for the fact that a court is not required to divide assets down to the penny if there's a reason to do otherwise. And that,
So what, and your argument is interesting in that you're saying it's not a quadro, but it's also not a bankrupt
right, just a money
risk
judgment.
$1,500 a month. And that's interesting. But what are the reasons that justify distributing the community property asset in the way that the court did versus a quadro?
The reason we argued the issue was because we felt that it was likely the mother was the appellant was 38 years old at this time, so having a quadro would simply divide up the money and put it into an account that she wouldn't be able to touch for many years until she was 59 and a half without paying these penalties. So our request for the monthly payments was a means to give her money that she could use now that was outside of that 10% penalty. Now, she could have received those payments, placed them into an individual retirement account, and she would be in the same position in terms of the ongoing investment tax-deferred accrual of benefits had she chosen to do that. She also had the
Higher
choice.
amount into a.
Well, as she received the payments of $1,500, she could take those payments which were coming out of a tax-deferred investment account and place them in another tax-deferred investment account if she chose to do that.
How would she do that?
She could create an IRA down at the bank and,
She could-
and
that-
make a
That would
deposit.
keep her, though, from, she wouldn't be able to use her other income, assuming she had enough money to fully fund an IRA. She wouldn't be able to obtain any tax benefits from this $1,500.
I don't think that the record would support that, in terms of what her other assets
But
would
I'm
be.
saying I don't think it necessarily supports that she could automatically get the same benefit from the $1,500.
The benefit that I was referring to specifically.
Is not having to pay
is
the
not-
penalty for an early withdrawal.
Correct. And then also the benefit that was discussed when Mr. Cook was speaking of being able to accrue interest that is also tax deferred. So that's the benefit I was specifically speaking to. She could have received that benefit by taking those $1,500, placing them in an IRA, and then earning interest that was also tax deferred had she chosen to do that. But the way the court did it, the court empowered her to make that decision. She was receiving $1,500 upon which she would be taxed. She would be taxed on that either way. That's a wash, as Your Honor said earlier.
But she's taxed immediately on the $1,500 if it's designated as spousal maintenance.
Correct. If it's designated as spousal maintenance, because this decree is dated before, the upcoming tax law will change that. If the decree is changed and dated later than that, then that
Can
won't
I
be the
ask you
same.
your
but-
view on, sorry, Jim.
Well, and effectively, the $1,500 payment by husband to her is $1,200
Right.
because it's tax deductible.
But it would have, yeah, but it would be she would be taxed on that anyway.
Right, but
Husband would receive the extra benefit.
This is
yes.
like those military retirement cases, yeah.
Can I ask you your view on, we asked opposing counsel about 25-318. In your view, is it obviously, I take it must be your view that it is okay to make an award of community property in the form of, you can divide community property and use a spousal maintenance award to make that division?
I think that I respect the case law that's been cited by opposing counsel, but I think that the statute leaves that door open. I don't think it is.
Doesn't it seem like a really bad idea for the reasons that
It-
have been
it-
proffered, that upon the death of the spouse, it completely changes the calculus? It seems like math never works if you're contemplating an award of $5,000 per month for 10 years, but it's cut off as soon as the spouse dies. How could you have an equitable property division?
Well, I understand that issue. There's pros and cons on both sides. Again, oftentimes we have judgments for.
What are the pros?
Well, the pros again. Oftentimes we
assume
have.
it's not a retirement account. It's just
Assume
there's
it's a-
$500,000 in the bank account.
Okay. Well, if the property exists, then I think that there's case law to support that the best way to do that is to simply, if it's liquid assets, to simply divide the liquid assets. And obviously, liquid assets in a bank account or something like that, I think that there's case law for an immediate
I'm
distribution
having
of
a
that.
hard time understanding why it's different just because it's a retirement account. Because we can put we could have someone come in and put a value on that. What's the profession that an actuary could
Yes.
come in and say, this is the value of that. And so it seems like a really bad idea to couch it as spousal maintenance rather than just a 50-50 distribution of a community asset.
Well, I understand. The reason for our request to the court was a way to get to mother who had very little participation in the case, done very little disclosure. We had very little information about what she wanted, why she wanted it. We wanted to give her the option of having money to use now in a way that would give her the option as far as what she could do with it. And that's why we made the request in that way. I do think that, the argument that the record and the reasons for the judge's order should be ignored or somehow entitle mother to both spousal maintenance and the division retirement. I couldn't disagree with that more strongly. I think that the record is what it is. I don't think that the record on appeal is parole evidence. I think it is the record on which the judge's decision is based. And to the extent, as we conceded in the brief, to the extent that there is an error, it would be an error in regard to the judge the judge calling the monthly payment spousal maintenance instead of making an alternate division in that way. But that affects the whole decree. So.
And if we find that that's an error, we can't just, can we just leave that out there and just say, well, he meant something else? Because it has tax consequences for the parties. Would we have to remand if we find that that's error to call it that?
I think that based on the record we have, I think you could make the finding that the decree doesn't reflect the court's order, and the court's order was that no spousal maintenance would be paid. Again, in transcribing that error in court, I overlooked the specific findings and saw them in the brief.
You would have us say that she's entitled to $1,500 a month that's not spousal maintenance, but is something else, but it cuts off when she dies, when there's not a specified term?
Well, I mean, that would be the nature of the court's order. And then if the court were to simply find if this court were to make the finding that the decree doesn't match the judge's findings and were to order reformation of the decree to match the judge's findings, then that would be that. I mean, it would simply be the order that is contained as a $1,500 a month judgment. If your honors find that it was error for the court to make the distribution of the $1,500 a month in lieu of a quadro or something else, then obviously I think you guys would be better judges of, whether or not remand would be necessary than I would, because it's kind of speculative for me, not knowing what the order is going to look like. Mr. Cook is correct that spousal maintenance is often used in settlement agreements and is often done because there are advantages to receiving a spousal maintenance order. Spousal maintenance order allows you to garnish the money directly from the other person's earnings if it's not paid. So if there often where there's property equalization judgments, where one party gets one list of assets, the other party gets another list of assets, and the values of those don't equal, a property equalization judgment is made. Those property equalization judgments, as I mentioned earlier, can be bankrupted under certain circumstances. They also, if there's simply a judgment for monthly payments on that, if the monthly payments aren't made, they're much more difficult to enforce. So
It seems to me too that I'm becoming aware now that this is not this. It's a tool that is probably better used by agreement.
yes,
And it's particularly cool because it's not a zero-sum game. You can lay off some of the cost to the government by turning what would be a taxable event into a non-taxable event, at least as to one party.
yes. I mean, I
Yeah.
can't disagree with that statement. So,
Interesting.
so I think that's all I have to say, and I'll yield the rest of my time. Thank you.
Thanks.
Thank you, Your Honor. Don't be fooled by this. Judge Katani mentioned the provision in ARS 25-318, which talks about child support and spousal maintenance, and that's 25-318R, which says, if any part of the court's division of joint, common, or community property is in the nature of child support or spousal maintenance, the court shall make specific findings of fact and supporting conclusions of law in its decree. I think you'll find that what that refers to is that sometimes the courts award lump sum child support or lump sum spousal maintenance, particularly where you have one of the spouses who's going to leave the country. This often happens when you have some rich spouse who lives in Monaco or Morocco or Addis Ababa or wherever, and so instead of giving monthly support when they have no way to garnish it, they have a lump sum amount that they give them, but they still get their half of the community property. And so nothing in 25-318A, which talks about dividing property, says that you can award spousal maintenance or child support in lieu of property settlement. Nothing says that. And all the cases say, to the extent they address it, say to the contrary. So that's number one. Number two, if the court had not awarded spousal maintenance, I would have appealed that. This case screams for it. You got a husband whose actual earnings are $11,500 plus per month, according to his own exhibit. $137,000 per year is what the federal government said.
How much did mother seek in spousal maintenance?
She didn't say, Your Honor, but then she doesn't have to say in spousal maintenance. And my client's got mental health issues. Pardon?
She doesn't have to make any request for it?
Well,
When they're in the context of husband not making a request for child support?
Well, the issue was raised, Your Honor. Husband raised the issue himself in his pretrial statement. And so the issue was before the court, and it was discussed before the court. So plainly, spousal maintenance was an issue, but here we have a 17-year marriage, a wife whom the court says makes makes minimum wage, where the husband's making $11,500 per year in terms of all the benefits and everything else he gets from employment. She's got mental health issues. She plainly doesn't have enough property, but within 319A1, I think, yeah, it's A1, sufficient property to support herself. She has nothing. The only assets that she's going to get of any significance are the retirement accounts. There's two, half of the FERS, half of the TSP she should get. But under Thomas, Gutierrez, and all those other cases, you shouldn't be considering those assets, the nest egg, with respect to spousal maintenance. And so that's what happened here, is basically what counsel just told you they did, was they wanted to give her $1,500 a month and have her spend her TSP to support herself instead of giving her half of the TSP account. And that's plainly wrong, Your Honor. There's no case authority to support that. They haven't cited any, and they have.
What's your case authority for not having to make any type of request for spousal maintenance, and then to challenge if spousal maintenance is not awarded when it was not requested?
Your Honor, I didn't brief that issue to this court because my client didn't appeal it. She was awarded spousal maintenance. And also, husband didn't appeal it. He didn't file a cross appeal. He didn't challenge it. Why would I brief that? My client agreed it was a reasonable amount. So she accepted it. I don't know why she can't do that.
I think the other side did suggest that that was an award in lieu of a property division.
Well, that was their idea. It wasn't what the court did. The court didn't make that order after court. They put it in the decree and the court adopted it. And so it became the order of the court. But it became the order of spousal maintenance is what it became. Yes, ma'am.
And your position is that the court entering a decree has an obligation to consider spousal maintenance and had adequate information before it to do so.
If it's raised, and it was.
And
Husband
how
raised
was
it.
it raised?
Husband raised it, Your Honor.
And what did husband said, I want to pay?
He didn't say that. He said he didn't want to pay. But he made it plain.
Where did husband say that? You mean in his testimony?
Yes.
Okay.
And so that's what was presented, but they offered to pay this, although he wanted it to be in lieu of property. And so he made the offer, and he stuck it in the decree, and there it is, and the judge approved it. It's just like Zale, Your Honor, where the court makes one finding. But if the issue were spousal maintenance, if they challenged that issue, then what I would do is I would present an argument why it should be there. And in fact, I address it in my reply brief, all the factors that are present that support the award of spousal maintenance. And under 25315A1, 319A1, wife has no assets with which to support herself. Her car won't support herself. The few pieces of furniture won't support herself. The only assets she could have to use would be the retirement assets, which under Thomas and Gutierrez, she's not required to use. So I don't think this should be an issue here. I don't think, with all due respect, I think this provision, this subsection R of 25318, isn't with respect to using spousal maintenance or child support as an alternative to dividing property. It's with using part of the property of the spouse who's paying spousal maintenance or child support to pay a lump sum support amount for the support of children or with respect to spousal maintenance rather than paying a monthly amount. So that's why they're asking for those findings with respect to that. But when they talk about the home, there's nothing in the record to indicate that the home was ever appraised. For example, husband got that. When they talk about offsetting child support, the child support was only $83.62 per month, Your Honor. This was not a big number that husband agreed to waive. That's their own child support worksheet. So thank you, Your Honor.
Thank you. Thank you to both lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll recess.